Also tense moments in federal court after the prosecution admits a second mistake to the judge. We're going to talk with an attorney following the trial of Dallas County Commissioner John Wiley Price when we come back.
Hey, welcome back. It is the first full day for the defense in the corruption trial of Dallas County Commissioner John Wiley Price and his co-defendant Daphne Fain. Attorney Chrysta Castañeda following the case. The prosecution got themselves in some trouble, not just once. This is what, the fourth time they've been scolded by the judge?
The fourth time that the prosecution has failed to turn over evidence that the defense is entitled to. This all happened at the very end of the prosecution's case, and the judge has been very clear in her unhappiness with the prosecution, even calling the highest U.S. attorney she could find down to the courtroom to tell them personally.
Right. Does this influence the jury in any way? Is the jury aware that this is going on?
The judge has given instructions to the jury that the prosecution has withheld this evidence and not turned it over in a timely manner. In a close case, it could make a difference.
There is literally a ton, probably, if you printed it all out on paper, several tons of evidence. It probably would fill this studio if you printed it out. Is the prosecution required to give just what they're going to use to the defense, or everything they gathered?
Well, there's a lot of procedural rules and constitutional rules about what they have to turn over to the defense, but generally speaking, the defendant is entitled to know what the prosecution's evidence is and receive exculpatory evidence well in advance of trial to prepare.
Anything exculpatory, meaning anything that might clear the defendants, anything that would work in favor of the defendants?
That's right, Tim.
Okay. John Wiley Price has said, and again, two people on trial, Price obviously the one everybody's watching, he's such a high-profile character, he has said, maybe I should take the stand. I'm going to follow my attorney's advice. You're an attorney. What would your advice be?
Well, in a case like this, I'd make a determination. Does the jury have reasonable doubt about the prosecution's case? If the prosecution has failed to prove the case beyond a reasonable doubt, I probably would not take the risk of putting Mr. Price on the stand. And it may be that there's enough there that the defense feels good about the case and thinks they're going to win.
And would just go to closing arguments, put up a couple of witnesses to explain explain their side of what the prosecution says, and then just use the closing arguments to raise doubts.
Exactly. And in fact, this has been a case that's really like a financial audit. The IRS agents are saying this about his books. We can expect the defendants will call expert witnesses to explain that about his books. And at the end of the day, it'll be the defense arguing that the case hasn't been proved beyond a reasonable doubt.
John Wiley Price is a guy who is known to be charming. Even people who don't like him, when they meet him in person, they come away going, boy, you know, what a charming fellow. Might his ego get the best of him and put himself on the stand?
I think he will follow his attorney's advice, whatever that advice is. I think he knows that that's the right thing to do.
And does a jury tend to follow the instructions? Some jury members are going to say, if he hadn't done something, we wouldn't be here.
There is that, but of course the judge gives a very explicit charge to the jury that you only consider the evidence and you consider that it's the government's burden of proof beyond a reasonable doubt.
Okay, so it's just their job to raise that level of doubt. Thank you very much.
Thank you.
Appreciate it.